Court of Criminal Appeals of Tennessee is now in session.
This is continuing the February docket of the Court of Criminal Appeals for the Western Section. The panel today, Judge Camille McMullen from Memphis, Judge Ross Dyer from Memphis. I'm Kelly Thomas from Maryland. You'll have 20 minutes aside. If the appellant wants to reserve some rebuttal time, please let me know when you begin your argument. And if you'll call the next case, please.
Ronald Honaker versus State of Tennessee.
Yes, sir.
Good afternoon, Your Honor. David Mays from the Shelby County Bar here on behalf of the appellant Ronald Honaker. I would respectfully request to reserve 10 minutes for rebuttal.
Did you say 10 minutes?
Yes, Your Honor.
Okay.
We come before the court today on a case that involves a guilty plea for a murder. And the appellant, Ronald Honaker, requests the court set aside that guilty plea based off his plea being unknowing of the discovery that was in the possession of the state at the time that he entered the plea, that he had no knowledge about, was not provided with from his attorney, and arguably was not provided with from the state. There's two different claims, and based off the appellant's argument, it doesn't matter who you believe. The defense attorney who says, I was never offered this confession by another person, or the state who says, we did offer it to him in a meeting when we were talking about a plea negotiation, but he didn't take it and we didn't copy it. Either way, the appellant, Ronald Honaker, was never given the confession of Cedric Monger in a case that was stacked in another envelope labeled other investigation. Now, the state argues that there's still a strong circumstantial case against Mr. Honaker, and that this confession is immaterial. However, you'll read in the transcripts that it appears I'm the only person so far that had actually watched the video, because despite the claims that I made in my post-conviction, both the prosecutor and the defense attorney still didn't actually look at the confession itself, which is not transcribed, but is an audio-video recording. And when the court considers the credibility or their belief of that statement, I certainly would hope that that would be taken into account. And I would strongly urge the court, and certainly I hope that the state viewed this video, because it's very material. A young man describes in detail how the victim, Bobby Hughes, was involved in a dice game, and that dice game led to Bobby Hughes shooting someone in a criminal charge, and the person that he was trying to shoot then coming back after him in retaliation, and that retaliation leading to a murder at a specific location that led to his body being wrapped in a multicolored blanket and stuffed into a wooden box. Now, these are very key, because the state likes to point out in their brief that, the court relied on the fact that there was this press release. But look at the press release. It's an exhibit that we made. The press release doesn't say anything about a wooden box, and it doesn't say anything about a multicolored blanket. It says a body was found wrapped in a blanket. Now, that's a pretty critical fact, that somehow in the days after the body was found, this confession of being the lookout to the murder somehow knew those very specific details. Nevertheless, Mr. Honaker can't make a decision until he knows that there's another person out there that has confessed to being part of that murder. He can't make that decision. The defense attorney can't give sound advice. The prosecutor shouldn't be given offers until they've personally reviewed it. He didn't even review it, even in the best case scenario of what the state's version was. When we came to meet to finally settle the case, I then haphazardly summarized 15 DVDs, which includes 2 one-hour taped confessions in a matter of 15 minutes that should be taken into consideration before you decide to plea. But also, if you don't take
leaving out of this, counsel, I appreciate your passion for the issue, but you're leaving out the fact that this statement was recanted, and that does that not bear on the issue to some degree, and bear on the fact that the prosecutor didn't, I guess, look at it with any real credibility in this case, because the individual was mentally challenged and also recanted it. So it wouldn't have been anything that the state could have used. I understand they still had an obligation to disclose it, but it was a recanted statement, correct? And this was a cold case, correct?
That's right. And perhaps if it actually was recanted by a mentally challenged person, that would be something that Ronald Honaker could have taken into effect, right? His defense counsel could have advised on that. However, who comes up with that description? It's Paul Hagerman. And Paul Hagerman, the prosecutor who's never actually looked at the video. And what I pointed out to them was this.
Well, he's looking at summaries from investigators on the other evidence, correct?
That's correct.
We both have not we both. The defendant, defense counsel had an investigator reviewing the evidence, and the state had an investigator, because we're talking about cold cases and connecting cold cases. You had a lot of information, and I think both the prosecutor and defense counsel had independent investigators reviewing the evidence. Is that fair?
It is. So what you have before the court then is a hearsay reliance of Paul Hagerman, that he says that his investigator said it's a mentally challenged person. I've looked through all 52 DVDs, and other than maybe his one line somewhere in thousands of pages of the investigator describing this as someone who's slow, there's nothing that supports that. As a matter of fact, this same Cedric Monger pled guilty to a case in Shelby County without any kind of mental limitations, right? Like this same exact person who was being investigated. The truth is, if you look in there and listen to T.L. Dean, Cedric Monger started getting threatened. Not only did he realize that he had just confessed to being part of a murder, but potentially the real murderers were out there saying, you better not be talking, otherwise you might be in trouble with us and with them. And that's what T.L. Dean, in his testimony in the post-conviction hearing, stands behind. I think that Cedric Monger had something to do with it, and Mr. McCrae. I believe that they did. He just stopped cooperating. And that's what, and that's why when I talk with Paul Hagerman and defense counsel Mitchell, I can't talk about these specifics because they never even looked at it. And that's why it's important to look through the entire file, listen to Cedric Monger himself. And
okay, so let's say, because I think what the trial court did was basically hinge her denial of relief on the fact that the offer was limited in time and scope. And so the defendant wanted the plea, wanted to get the case wrapped up, got a favorable offer. Is the onus still upon defense counsel to go through all those hundreds of thousands of documents? If you've got an offer that's definitely favorable, I think the death penalty was on the table in this case. Speak to that.
A confession by another person of a completely different theory seems to be one of the most material things that is left out of a case. So absolutely, if the state knows, someone knew, and whether or not Paul Hagerman knew or not, his testimony was that he kind of knew that there was some recanted thing. Well, that's why it's so important that I included that actual piece of evidence so the court themselves can review it and see how critical this confession, how specific it is, and how important, therefore, it was not only for the state to know about it and then to provide it to the defense and say, whoa, before you plead guilty, you might want to consider there's someone else that's confessing to being a part of this murder twice. And oh yeah, maybe he's recanted, but how many times do people confess to crimes and then realize, oops, I said the wrong thing, and or I pointed the finger at a dangerous person? And that's exactly what happened in this case. And
so the other question is, so what you're doing is, and we oftentimes get these situations where the relief, even if you're entitled to relief, is going to undo this entire guilty plea. Is that what your client wants? If you get the entire global guilty plea, which was, I don't know, multiple aggravated robberies, I think. You would know better than me, counsel, but I got the impression that he got the benefit of a concurrent sentence for multiple other Class B felonies. And is he prepared to accept that if he gets relief in this case?
That's interesting, because first, we didn't plead to set aside the other guilty pleas. Now, whether or not procedurally the pleading for the murder charge itself would then somehow connect the other two pleas, which are independent case numbers, and while they're done on the same day, they were never pled in the post-conviction.
I thought this was a global plea.
Yeah, that's what I thought too.
It was a global plea. However,
I mean, that was the whole reasoning behind him getting it packaged up and quickly accepting the state's offer, was because they packaged it.
That's right.
At least that was my impression from the briefs.
Yeah, it is my understanding that if that's the consequence, that it's all set aside, that is his intention.
Okay.
However, from a procedural standpoint, the other counts weren't pled to on a post-conviction because he pled guilty to those. And while they might have been some sort of global package deal, I don't know any procedural law that says, oh, if you plead to this one and plead to this one, they both have to get put aside if there's a Brady violation or ineffective assistance of counsel in one case.
Well, that's part of the plea process. Is if I've got 4 or 5 cases, and the state comes to me and says, "Look, I can wrap up all 5 of these cases, even if they're different indictment numbers, and if you're willing to take X number of years and this one, and I'll even take the death penalty off the murder case," and he packages them all as one plea deal, you're still going to enter 5 pleas to 5 indictments, but it's all part of one deal. I think that's what Judge McMullen's question is if we understand the record, and I noticed the state shake their head in agreements once or twice, so we'll get that answer from them. But if all 5, even if you're just challenging the murder, you undo the entire guilty plea because that's part of the deal.
And then if that's the case, I still think that would be the relief that would make my client.
I think what Judge Mullen and I are saying is we just want to make sure that one, we understand it, and 2, your client understands that if we give him what he's asking for, it's not just the murder case. He's going to face, if we're right, he's going to face trial and not new charges, but he's going to have to face all those charges that got resolved as a part of this guilty plea.
Yeah, and I didn't find, prior to this, I wasn't able to find anything that delineated that, right? From a procedural standpoint, if there's a active case from cause number related to this murder, then certainly that's not how I read the law.
Does your client? Okay.
Yes,
but you got a legal. Yeah, if you get relief on this is going to undo the agreement you had or your client had with the state. Okay, So I don't know what law you're looking at, but the agreement in and of itself, based on what I've read, was a package. And so that package will no longer be in existence, because he's now requiring the state to go through with the trial. And the state is going to say, deal is over. We got to try case 1, case 2, case 3, and I think there's a 4th one. And when that happens, the state is not required to give you a deal, a partial deal. There's no deal. Does that make sense?
That's fine. That's fine, because I think we'll stand behind the basic premise is the global plea is flawed. He can't make a knowing decision without knowing the full facts of all the cases, which he didn't.
I agree. I agree with that premise. We can leave it at that.
I think that's my time. I might have eaten into some of my rebuttal. If y'all want to take some away from me.
No, you still have, well, yeah, you've got 5 or 6 minutes left.
Thank you, Your Honor.
May it please the court, Catherine Decker representing the state of Tennessee. The post-conviction court properly rejected the petitioner's Brady claim, properly found that the petitioner's counsel was not ineffective, and properly found that the petitioner entered his plea knowingly, voluntarily, and intelligently. I'd like to turn first to issue number 1 concerning the Brady claim. Just to make things clear, we're talking about 2 sets of discovery, and in the record, the first set of discovery is about 400 pages of written documents, which is in Exhibit 3 in the appellate record, and about 36 CDs. There's no dispute that that set of discovery was turned over to Mr. Mitchell, defense counsel.
Is that related just to this case, or is that to the whole global picture?
In that, those 400 pages of discovery, you do have, because, Honaker was a suspect, and so they pulled up his criminal record. So you do have some documents relating to the criminal record, which includes the 2 other offenses that he pled to, but primarily it's about the murder. Okay. And then Exhibit 7 in the appellate record is the 175 pages of written documents, and that we're considering we're calling the second set of discovery, and then there's 16 CDs. So the post-conviction court properly denied the Brady claim on 2 grounds: that the state did not withhold the second set of discovery, and that the second set of discovery was not material. The issue can be readily disposed of even on the first finding for 2 reasons. First is that the post-conviction court's finding was based on a credibility finding, considering the prosecutor, Mr. Hagerman's testimony. So at the post-conviction hearing, the prosecutor testified that he met with Mr. Mitchell about 10 days before the plea. The plea was November 13th. The prosecutor then wanted to say August 15th to 20th. I think he might have meant October, but it doesn't matter. He met with the prosecutor met with Mr. Mitchell about 10 days before the plea, or as early as August 15th. And according to the prosecutor, he had the second set of discovery on the table. The purpose of that meeting was, number 1, to convey a plea offer. Number 2, because he had been given the second set of discovery. The prosecutor recalled that he and Mr. Mitchell went through the paper discovery and then looked at the labels on the CDs. That was his recollection. Mr. Mitchell doesn't say that didn't happen. Mr. Mitchell doesn't have a clear recollection of this case. He gave all of his files to the first post-conviction attorney, and he just, you'll find in a second, he really doesn't have a very clear recollection of the case. Well, first of all, he said he had never heard of Cedric Monger. Cedric Monger's name is on the very first page of the first set of discovery. He just doesn't recall. So he said at the post-conviction hearing, I'm not saying Mr. Hagerman is not telling the truth. I simply don't recall getting the second set. So first, the post-conviction court made a credibility finding that Mr. Hagerman's testimony was true. And so, and because this court defers to credibility findings, that's the first reason to uphold the denial of the Brady claim. But most compelling in disposing of this claim is an entry in Mr. Mitchell's own billing records. I have not cited that entry in my brief because it was not until preparing for this oral argument when I reviewed all 600 pages of both sets of discovery that I made the connection. So if you will look at the entry for October 24th, 2012, which, just for the record, it's on volume 4, it's exhibit 12, this is billing records. And it's, when I pull it up on my computer, it's page 194 of volume 4 of the appellate record. This is what Mr. Mitchell says in that billing record. Review discovery, watch SCSO video crime scene picture, warrant info, 2969 Eden photos, and NCS 3208 Madewell photos. That is the important part of the entry. 3208 Madewell photos only appear in the second set of discovery. That 3208 Madewell is actually the address of the home where Cedric Monger said where the victim was killed. That is the address of that home. There are 2 photos in all 600 pages, and they actually appear, just for the record then, volume 4 of the appellate record on pages 164 and 165. Those are the only 2 photographs of 3208 Madewell. And I think on that fact alone, we know that Mr. Mitchell was provided that second set of discovery. Either he copied it, or it's true, the trial court was correct in finding Mr. Hagerman's testimony true, which is that they reviewed all of that discovery during that meeting that Mr. Hagerman recalled. And in fact, there's only 172 pages of that second set of discovery. So these photographs were at the tail end of that. So that confirms Mr. Hagerman's testimony that they reviewed all the way down all of those documents. So I think for that reason, this court should affirm the post-conviction court's denial of the Brady claim based on the finding that the prosecutor did not withhold that second set of discovery. Have I made the record clear, or would you prefer a post-argument letter? Where have I made it clear where those photographs are and where Mr. Mitchell?
It's clear for me, and I'm looking at the exhibits. You said it's in volume 3, page 192.
Volume 4.
Volume 4, exhibit 12.
I'm giving you these page numbers because I don't want you to have to sort through 600 pages.
I certainly appreciate that.
Yeah. So exhibit 12 is his billing records, and that's on page 194 when I pull it up on my computer.
Okay.
And then the photographs are on volume 4, page 164 and 165. So unless there are further questions about that, the Brady claim, what I would like to do now is to pivot to his second claim of ineffective assistance of trial counsel, partially because the prejudice prong is virtually the same as the materiality prong on Brady anyway. So, but let me focus on that the second claim of ineffective assistance of trial counsel, where he claims that Mr. Mitchell was ineffective for failing to review, but we know that's not true, investigate the second set of discovery or discuss it with the petitioner. This entry in the record makes it a little bit unclear whether he didn't discuss it with his client, because at the post-conviction hearing, Mr. Mitchell testified that had he had the information about Mr. Munger, he would have relayed it to the petitioner. So, but in any case, Judge McMullen was absolutely correct that the case law, and I've cited 2 cases in my brief, Taylor and Branham, that the case law provides that counsel is not ineffective for pursuing a plea offer before they have reviewed and investigated all discovery. Sometimes in cases like this, where, as Hagerman testified, this was an offer that was, time was of the essence, the trial counsel can pursue that without having investigated all the discovery. So that's the deficiency prong of his second claim. But as to the prejudice prong, the standard is whether there was a reasonable probability that if the evidence had been disclosed or reviewed in this case, the petitioner would have proceeded to trial. And the post-conviction court properly found there was no reasonable probability. And this is a situation that the defendant was looking at. First of all, according to Mr. Mitchell, from the outset, he was insistent on pleading guilty. From the outset, he made that known to Mr. Mitchell. And he had good reason for that, because he was looking at 3 offenses at this time. He was looking at especially aggravated robbery, for which, as was stated in the plea hearing, he beat and stabbed the victim, who spent several days in the hospital. So you can imagine he's looking at quite a severe sentence. And actually, because of his lengthy criminal history, he's actually open to a life sentence for that conviction. He was also looking at charges for aggravated robbery, aggravated burglary, and possession of a weapon during the commission of a felony, for which he has confessed. So, and even on that offense, he was subject to a life sentence. So and then we have this murder charge with, as Mr. Mitchell said, very, very strong evidence against him. He had 2 jail.
So as you're describing it, I want to go back to the question that Judge McMullen and I were asking of the appellant, and that is, the way you're describing it seems to confirm what we were asking. That is, this plea took care of numerous outstanding charges that this defendant had, not just this one murder charge.
Yes, Ron.
It truly was a global package deal.
It was a global package, which is why Mr. Mitchell described it as the best deal he had ever seen.
Okay.
In any case, also concerning this murder, they had witnesses that testified about a violent encounter between the defendant and the victim just a few days before the murder. We have 2 jailhouse informants who came forward to say that the defendant had confessed to the murder. You have what seems to be, I think, his co-defendant in one of the pending burglar robbery charges, Mr. Coop, who also testified that the petitioner had confessed to him. You have the petitioner giving a false alibi, which evidences his guilt. You also have the fact that he lived at the home where several witnesses, when they saw photographs of the victim, the victim was in a flowered shower curtain or comfort or something in a trunk. Several witnesses linked that comforter or shower curtain and the trunk to the home that the defendant lived in. So you have him insisting on pleading guilty and strong reasons why he would want to plead guilty. He knew the exposure if he went to trial, not just life sentences, but as Judge McMullen said, the death sentence was on the table for this as well. He was overjoyed, according to Mr. Mitchell, when he received the state's offer. So that's on one hand. On the other hand, you have Cedric Monger's confession, which, as Judge Barr has said, was recanted. And before the recantation, fully investigated by the police. They even arrested one of the named suspects for a 24-hour hold and release. They had no evidence to support the allegation even before the recantation. And finally, Cedric Munger told the law enforcement that he had lied and he had obtained this information from somebody else. So you have strong reasons to plead guilty, strong evidence to support all three charges, and on the other hand, fully investigated and debunked and recanted confession from Cedric Munger. Mr. Mitchell testified at the post-conviction hearing that even if he had all the evidence about Cedric Munger, it would not have made him change his advice to plead guilty for all the reasons I have just stated. Finally, at the time he pled guilty, the petitioner was not completely ignorant about the investigation regarding Cedric Munger. If you look at the first set of discovery, it is replete with references to Cedric Munger, Dominic McCrae, Titus Washington. These are the people that Cedric Munger fingered in made allegations against for the murder. It is replete with their names as suspects, the fact that the police took buccal swabs, the fact that there was DNA, replete with references to a Chevy Blazer. That's the car that Cedric Munger said the victim was transported in. Absolutely replete with these references. So Mr. Mitchell and the petitioner already knew this name Cedric Munger. Furthermore, Rachel Geiser, who was the investigator, her summary included references to Cedric Munger. And at the bottom of her summary, she said, "We do not have all the documents and CDs." So the petitioner pled guilty knowing he didn't have all the discovery. And it goes back to the point that trial counsel is not deficient and the petitioner completely has the right to pursue and has not been somehow harmed by pursuing a plea, even though everybody knows that the discovery is yet to come. For those reasons that I have stated, the post-conviction court properly found that there was no reasonable probability that the petitioner would have proceeded to trial had he been provided with more evidence than he already had about the Cedric Munger investigation. Just finally, I want to touch on something that Mr. Mays said, and that is about whether Mr. Honaker could have pled guilty not knowing all the information voluntarily pled guilty without knowing all the information. The question, the legal question, when presented with whether a plea was voluntary, is not whether the petitioner knew all the information. The pertinent question is whether he could accurately assess the risk he might face of going to trial. That's the question. So, of course, the petitioner did not have all the information about Cedric Munger, if in fact Mr. Mitchell didn't convey it to him. But he did have an accurate assessment about his risks of going to trial. He knew all the facts against him on all three cases. He also knew, and if he had more information on Cedric Munger, his initial assessment would still have been accurate, which is that he was going to get convicted and he was exposed to life sentences, especially even for the one he had confessed, the charge he confessed to. And having more information would not have affected that assessment of his risks. So for that reason, I ask this court as well to affirm the post-conviction court's conclusion that the petitioner's plea was entered voluntarily and knowingly. And with that, I just ask this court, unless there are any questions, I ask this court to affirm the post-conviction court's denial of relief.
Thank you. Rebuttal?
Thank you, Your Honor. It's about making an intelligent decision, right? And how can you make an intelligent decision when you don't know that someone else is confessing to the crime? And it is undisputed that Mr. Honaker never got that confession. Charles Mitchell is adamant in his testimony that I was never offered another confession. And his testimony, and Paul Hagerman is
It is not undisputed. It is not undisputed. It is disputed. Did I hear you right?
Yep. Mr. Charles Mitchell agrees that he never got a copy of that and never provided a copy. He knew nothing about a confession. And he says that he doesn't, and Paul Hagerman confirmed that it was never copied. So when we go back to the beginning, the first argument that he's looking at this one photo, and since he claims this one photo in his bill, then he must have it all, then where's the confession, right? The confession video is the key piece of evidence that you have to know about. From the state perspective, you must know that someone is confessing to this, and then you must fully disclose that to the other side and say, here's a confession, you need to take it. And in his testimony, Hagerman's testimony was Paul Mitchell refused to take it. Charles Mitchell's testimony was, I don't remember that meeting. I don't remember being offered any evidence. And as a defense attorney, you were always looking for some sort of edge to have something in the case. Now, while he goes back and says it wouldn't affect his decision and his advice, ultimately that's Mr. Honaker's decision. Mr. Honaker gets to decide whether or not he pleads guilty. And the only way that he can do that is if the people who have the information, which in this case is the state, or his defense attorney, whoever has it, assuming his defense attorney was told about the confession, then his defense attorney has to then go and tell him that, hey, there's a confession out there. And but in the trial, in the plea transcript, it says, I gave you 36 CDs. I gave you all the discovery, which is not the case. There's 52 CDs. And it's clear from the plea transcript that he didn't have the other 52 CDs. I mean, the other 16 CDs. And Charles Mitchell's testimony in the hearing was, I was never given anything else in a file that said other investigation. And he says he wouldn't turn down a confession. He's always looking for something. The state also relies on time as an essence, right? If you look at the timeline, this was the first investigation, the other investigation in the other folder that was definitely, indisputably never copied and arguably never even relayed to the defense counsel. That was immediately after the body was found. This is months later, but yet time is of the essence to the prosecutor who's threatening a death penalty enhancement on this. But at the same time, he's got 16 more DVDs that he doesn't even look through himself. And time is of the essence to him. Why? Why is time such an essence in a case that's several months old? It's a squeeze. And if and Honaker is insistent on pleading guilty, we can't take that against him because he doesn't know about the confession. We can't look back and say his decisions were intelligently made at the time because he didn't know about Monger's confession. Now, whether or not it's material ultimately goes back to the specifics of what he knows. And there's no other way that he would know about that even if he recants, even if he stops cooperating, whatever it is, it's material. When he describes exactly what happens, then the cadaver dog goes and hits on this. Mr. McRae runs and he's he's fleeing. Then he comes in, he doesn't cooperate, and then they keep questioning him. His story isn't matching up, and They ultimately release him, and then Cedric Monger stops cooperating. But just because they don't charge him in that case doesn't mean that Mr. Honaker shouldn't be given that and given an opportunity to make an intelligent decision whether or not he wants to plead guilty to a case. Even if his exposure is astronomical, he still should have the opportunity. That doesn't mean it's okay to put another case on him and say, oh yeah, plead guilty to this one too, because it's not going to matter in the grand scheme of things. Well, it does matter. And the only way he can make a decision on that case is if he's given all of exculpatory evidence. And his lawyer has a duty to explain it to him. The state has a duty to give it to him. He has a constitutional right. And that constitutional right is violated when he wasn't given that confession, regardless who it is that prevented it from him having it. That plea must be set aside because he couldn't make a knowing plea without seeing that confession beforehand. Also, the state stands behind Charles Mitchell's description of this being a strong case. But even Paul Hagerman, in his testimony in the hearing, said, this is obviously a weak case that we had. That's why I offered 27 years on second-degree murder in the murder charge, because it's purely circumstantial. And it's the 400 pages. Oh, and as far as one other error by the trial court, she relies on the number of pages to justify, oh, this is why it must have been turned over. But those pages, if you look at his bill, he gets pages of discovery for the total 600 before the murder indictment even comes down. So the total number of pages that he charges for in his bill includes both the discovery for the armed robbery charges and the 400 pages that he got. But the pages don't matter nearly as much as the video. And the video is the key piece of evidence that Mr. Honaker must have been given. And
thank you. You've used all your time. All right. Thank you for the arguments. I believe that concludes the docket. Am I correct?
Yes, Your Honor. This honorable court is now adjourned.
Thank you.
Thank you, Your Honors.
thank you.
Thank you.
Thank you.